Hey everybody, thank you all for joining. We are going to get started in a minute. I will say I apologize for having this on Inauguration Day. I know some people are probably wanting to watch, but when setting up my calendar in December, I did not even think to check for that. And honestly, I thought it was on Thursday. So I just was messed up on the dates, but I apologize. But this is going to be a quicker one. So I will have you all off in plenty of time to watch. Continue watching, or if you'd already started. So we will go ahead and get started. This is being recorded because I know some people couldn't attend today. So we will post this on my YouTube channel and I'll get it sent out to everybody as well. So this is just giving me a quick one on when do I need to kind of update my estate plan and looking at some tax considerations going forward. So if you haven't joined, I think most of you have joined my webinars before, but if you haven't, a little about me. I'm a graduate of the University of South Carolina, School of Law and undergrad, and my main practice areas are estate planning, Medicaid planning, and business planning. So that is why I'm hosting this webinar today on estate planning. So we're going to kind of overview of estate planning real quick, when to update your plan, and we're going to talk about the Secure Act, and we're going to talk about tax considerations for estate planning in the future. So real quick, estate planning is just creating documents to handle how your assets will be distributed at your death, such as through a will or trust. It's part of estate planning. We like to talk about life planning as well. And life planning is part of estate planning, but it's creating powers of attorney for financial and for medical reasons. So I recommend everybody having these powers of attorney when you go to do your estate plan as well. So the first thing we're going to talk about is just when do you typically need to update an estate plan? I know a lot of people wonder, well, do I need to do this often? When? I think the biggest times you update it is if there's a death of somebody, you may have left them as a beneficiary. You may have them as your personal representative. So I think you have a death of somebody in the family, that's a good time to talk to your attorney. But also if there's a birth, so it's not all negative events that happen, there's some positive things. So you have, a new child, a new grandbaby, you want to add them as part of your estate plan, that's a good time to update and talk to your attorney as well. Anytime there's a marriage, you want to make sure you update that as well. So a lot of times with my clients in second marriages, if they're wanting to make sure that everything stays with their kids and not to their spouse, which both people agree on this, that's the time you want to have a prenuptial agreement and look into having an estate plan as well that follows that. So marriage, time to update. And the marriage, you probably want to update those powers of attorney, healthcare power of attorney as well. And then divorce. If you are no longer with your spouse, you definitely don't want them to inherit all of your assets, and you don't want them to be your power of attorney as well. Sometimes we write these documents like a power of attorney that a divorce would change that, but sometimes that language isn't in there in older documents or in documents in general. So you want to make sure you talk to your attorney if you do get divorced. Technically, if you're divorced in South Carolina, it should eliminate your spouse getting everything, but I would go ahead and update it. I don't want any questions or anything on that. You want to make sure it's clear and in writing. The next thing is if there's changes in tax law, which we're going to talk a little bit about today. If there's a new law or taxable implication for your estate plan, you may need to do some updates with a little bit more tax planning in perspective. You don't want to not update your plan and then pass away during this time and have your family have a big taxable event you could have possibly avoided. In general, I say every 3 to 5 years, you want to check in with your estate planning attorney. Sometimes you're not going to catch all the new laws that come out, or maybe they're not publicized as much as what they should be, so you didn't catch it. So I think it's a good thing to check in every 3 to 5 years. Most of the time, if your attorney is sending out, like I tend to send out all these blasts to everybody. So make sure if you see anything like that, I'm going to try to keep everybody updated if I see something crazy happening, but you definitely want to make sure that you keep up with everything on the tax planning perspective. So checking in every 3 to 5 years is a really good idea, because you're not always going to think, oh, I got divorced, let me see my estate planning attorney. You're pretty much focused on your family attorney at that point. So what we're going to talk about now is kind of what I wanted to spend most of the time talking about. Is kind of some of these tax changes and plans that may have impacted your estate planning that you didn't know about, or you may want to have changes made now that you know about this. So the first thing is the Secure Act, and it was established in December of 19. So it was established right before Christmas. I think it was December 23rd where this was passed and went into play. And there's not a lot of litigation on this act yet. So everything is just what we've learned through the IRS regs and what we've learned through various different articles that have been published on this. But pretty much what happened with the Secure Act is the big things. It changed your required minimum distribution. So previously you had to take this at 70 and a half. Now you don't have to take it till 72. And you can continue to make contributions to your IRA no matter what age. The big thing that this affects with estate planning is this 10-year distribution rule. I will say when talking about the Secure Act, always talk to your accountant and your financial advisor as well. I don't give tax advice. I'm just trying to go on how this affects your estate plan. So, but it's 10-year distribution rule. So distributions must be taken within 10 years with limited exceptions. So what this means is used to, before this was passed, an individual, so say you're the surviving spouse, and you have left your IRA to your 2 grown children. So they could roll it into their own and take distributions based on their own life expectancy. So they didn't have to take it within 10 years or within, a certain amount of time. They rolled it into their own and drew it. They had a long time to spend this money. So the taxable implications didn't happen, right away or all at once. It was a long time to do this. Well, this is the big thing that changed. Now these distributions must be taken within 10 years. So you give it to your adult child and they have to be able to pull all this money out with 10 years. So that way they're paying the taxes on it earlier. They're not getting that lifetime spend out. They are only doing it 10 years. So this makes a difference on estate planning for people because your children are going to pay taxes quicker. It's not really in theory that they're paying any more taxes or it's changing it, but they're moving it up. You're not getting to do it over your life. You're doing it in 10 years. So that does make a big difference. There's exceptions though. So if you have a spouse, they can still get that lifetime spend out. If you have a minor child, they get an exception, but theirs is limited. They're not going to get it for their entire life. They're going to get it until they're 18, and then the 10-year rule applies, is what I've understood. Now, a disabled individual, so if you have a child that is receiving Medicaid or special needs in those senses, they can get the lifetime spend out. So that's something you may want to consider with having special needs or disabled children in your family. Or adults, so it's a disabled adult as well, not just a minor child, they can get that lifetime spend out. So there's certain language you want to have in there to help them with this to make sure it doesn't hurt their Medicaid eligibility or anything. But that's definitely stuff to consider when looking at IRAs now, because IRAs, 401ks, 403bs with this 10-year distribution rule, it really did change how people planned with their estate planning for their retirement accounts. So the next slide we're going to go to is, how does this 10-year impact my estate plan, which is the real reason I wanted to talk about it. I think it's really important that you look at reviewing your beneficiaries of any retirement plans. So you want to make sure probably you have your spouse first, because you're probably going to want to leave that to them. And they're going to get that lifetime spend out. You may want to think, well, I have minor children, or I have a special needs child. They can be an adult, but I want to leave it to them because that's going to be a better tax implication for me. So I think that's important to consider those things. I think it's also important to look at, you're thinking you may want to do some charitable giving. You're thinking, I want to leave something to my alma mater, to a charity, to a hospital that's really been there for my family, to my church. I want to set up an endowed scholarship somewhere, those type things. This may be a point where you want to look at that 401k or IRA and say, okay, let's look at the big picture. I have X amount of money and I know I want to leave a third of my estate to charity. This charity may get the biggest benefit from me leaving this IRA and leaving more of the real estate that has about the value I want my family to get to them. So I think it's important with that situation to look at the overall picture of your retirement accounts and see what my goal is, and to look and see if this is a good time to do some charitable giving, or I have a disabled child and I want to make sure they're protected. So instead of giving them this lump sum of cash I had thought about, maybe I want to look to give them my IRA so I can have a better tax benefit for everybody. So I know everybody's always been cautious about leaving an IRA to a trust. So technically, if there's not certain language into a trust, you have 5-year distribution rule, which isn't as big of a deal now because we have 10-year rules. A 10-year, 5 years is still going to be a bigger tax implication, but not quite as big. So there are trusts specifically written to handle IRA accounts or retirement accounts, 401ks, to make sure that you get the biggest benefit, so that a person is not counted as a trust, but you're counted as a qualified individual. I think that's important to think about when you're setting up this trust, is you need to let your attorney know, do I plan on funding it with retirement accounts, or do I plan on leaving those outside? Because you want to make sure, if you plan on funding it with IRA accounts, that your trust is set up for that reason as well. And I think as the laws have changed, some language in the trust may need to change to make sure it goes with this Secured Act law, to make sure it upholds what needs to be in there. And you might want to set up even a special trust if you do have a disabled individual, to keep it Medicaid compliant and allow for that lifetime stretch out. And I did do a webinar on the Secured Act with special needs individuals this on my channel, so definitely check that out if you're thinking of that. But I think those are kind of how it really impacts your estate plan right now. But as always, is the Secure Act going to be repealed? This was passed during a different administration, and today everything's changing. We're having a new president. We're having new Congress. Every 2 years we get a new Congress. So these laws can change. So I would say possibly with a new Congress and president, these prior acts may be repealed, such as the Secure Act. Looking at what's been going through the House, it looks like in November 2020, they were putting out the Secure Act 2.0 from my understanding. So with a new Senate, a new House, new group of Congress, different people on those financial ways and means committees and everything, tax committees. So things may change. So I think it's important to know that this Secure Act is the law for now, but laws change and evolve over time, as we've seen. So you have to make your plan based on what the law is now, but know that if this act changes, we could go back to getting that lifetime spin out. We could change it to only be in 5 years. So I think that's important to know, that we're planning our estate plan for what the law is today. So we're planning it with the Secure Act in mind. And since it's only been around a year, probably a lot of people haven't made plans with this Secure Act in mind, but we do plan for what we know now. So the next thing I kind of want to talk about is the estate tax, and what this is and how it impacts individuals. So the estate tax is a tax on the person's assets after death. So right now, an individual in 2020, and is still going on right now, has an exception of $11.58 million for the federal estate tax. So if you're a married couple, we have what's called portability, and you have to make this election when the first spouse dies. But your accountant, your attorneys, everybody should help you make these decisions if you call on them during a time like this. So roughly a married couple is going to have about $22 million in assets before having to deal with an estate tax. So most of us do not have to worry about this issue. We do not have $22 million in assets if we're married, or if we're single. Most people are not having $12 million in assets. This is the federal level. So some states do have their own estate tax. South Carolina does not at this time. I don't believe I haven't done a lot of research into the past, but I don't think we have an estate tax typically. So you don't have to worry about anything from the state. It's all from the federal level here in South Carolina. So right now, the law is set that the federal estate tax is set to drop to $5 million per person. So approximately $10 million per married couple with inflation. So the numbers could change a little bit in 2026. That's how the law was written. So right now, the $22 million is technically in place till 2026. Right now, a lot of people like to make gifts to their family members. So the annual gift tax exclusion is $15,000 per person. So this means that you could give $15,000 to a person with no taxable implications. So, for instance, if you're a married couple and you're wanting to help your children out with buying, you have adult children, your son just got married, him and his wife want to buy a house, and you want to help them out, but you don't, and you're wanting to give them, a decent chunk of money, but you don't want to pay taxes on that, and you don't want to have a gift tax implications. That means wife could give 15,000 and husband could give 15,000 to son for a total of 30,000. So that's a pretty big gift. But say, you really want to help them out and you want to give them, their full down payment, and you want to give them enough so it can cover, a little bit of paying their mortgage. So you give son 15 to 30,000 from husband and wife, then you're going to give your daughter-in-law 30,000. So you could technically give about 60,000 without a taxable implication, which is important when you're thinking about your estate plan and your overall goals and how you want to help your family. And sometimes you don't want to wait until your death to be able to give your children a gift to help them out. And things you can always think about with your estate plan is if you do this gifting, we could have it that they don't get as much in the estate plan. So you gave son and his wife 60,000, but your daughter didn't need help. She bought her own house, but you don't want her to be hurt in the long run by not getting as much. So we could definitely do this and help you with an estate plan that deals with your life gifts, plus make it better for death gifts so everybody's counted even. If you go against this, we may have it count as your total estate tax. One thing about estates, they can be taxed up to a 40% tax rate right now. So it's a pretty high tax rate if you do have a taxable estate. So could this change with a new administration? In this webinar, I'm not trying to be political in any way. I just want to give everybody an understanding of when I need to update my estate plans based on the laws and everything happening at the time. So possibly yes. So current proposals, this is just proposals. Nothing has been put into play. So the current proposal is the tax fund turn from, this is Joe Biden's, what I've read. His current proposal could change, Congress, they're not going to always agree with what the president wants. So this doesn't mean that anything's going to be there. It just means this is possibly stuff that is on the table right now that could change with a new administration. So they may want to take the exemption level back to the 2009 federal level of 3.5 million per individual. And we did have portability then, so I think we would still have that portability. So it'd be about 7 million for a married couple, but possibly having a 45% tax rate on an estate tax. In many administrations, they have tried, and this is part of a possible tax plan, to repeal a step up in basis. So what this means is if you bought your house for $30,000 and it's really worth $150,000 when you pass away, well, your children, you're going to your children and they inherit it. You don't gift it; it's inherited to them through your death. And there's that $150,000 what your house is worth now. The children get the basis of $150,000. They don't get your $30,000 basis. And this is a huge deal for when you're selling assets with those capital gains, taxes, and implications. So I will say this has been tried multiple times and it has never been approved. So while it could be on the table and discussed realistically, I don't see them getting rid of this step up in basis. I think it's probably there to stay. And I do think portability is likely to remain in future legislation because we do value the family unit and taxes. A husband and wife, pay taxes together most of the time. So I think that's there to stay. But there is a possibility that your estate plan may need to change because if we do go back to that 3.5 million, you may need to look at some more estate taxable issues. But the thing is, nobody knows what's going to happen yet. This could completely change. None of this stuff could get passed. And once again, all this stuff changes constantly. So like I said, every 2 years, we really have a new House and we have a new Senate. So our Congress is new because different people are being elected. There's different shifts. So the thing is, while we're getting a full new administration now with we have the House, the Senate, all every 2 years is changing. We also have a new president, which is going to change typically every 4 to 8 years. So all this stuff is constantly changing and the laws are constantly changing on this. So I think that's why we don't think if an estate plan is set in stone. We do need to be aware that the taxes and the estate tax will change. So that way, we may need to go and do new planning. For instance, people who were doing their estate plan 15 years ago, the exception at that point, I think, was maybe 600,000. So, I mean, a lot of people were having to deal with tax plan. Then it shoots up to, $11.5 million. That's a really big difference. So I think it's always important to be aware of these things with your estate plan. So the question everybody asks is, will I need to update my plan? So if there's new regulations regarding the estate tax, I think that's when it's a great time to talk to your team of advisors, such as your attorneys and your accountants and your financial advisors. You may have to look at more revenues and avenues for tax planning, such as we're going to think of maybe an AB trust that allows for a spouse to disclaim. So maybe we get a better tax implication. We look at things like irrevocable trusts or maybe our life insurance policies. We're thinking of charitable giving. So maybe this is a time we look at different types of charitable trusts, like a charitable lead trust, or we look at maybe an annuity with a charity. We look at charitable giving. Maybe we want to up our charitable giving in the future to make sure it's doing everything we want to do to best benefit us for tax purposes, for our estate plan. Maybe we want to learn how we're going to treat life insurance. So I think that's the point where if you do see, hey, this has really changed and I may be borderline on being on the estate tax level, let me go talk to my accountant, let me talk to my attorney and my financial advisor to see what's right for me. And you need to know your overall goals. I think that's what's important. Do you want your children to pay? Do you want your children just to have it all and not worry about the tax implications because that's on them? Or are you thinking, oh, I know I want to leave so much to a charity, so let's look at that? Or do I want to just make sure I do the best tax planning possible so me and my spouse maybe have some elections we make at our death to help everything? So I think that's the kind of conversation you need to have with all your team of advisors. I think it's why you also need to make sure you keep in touch and in contact with all these people for changes in the future. I don't give tax advice. That's what I'm going to send you to your attorney. So to your accountant. I think it's always important to make sure your accountant, your attorney, your financial advisor are all on the same page to do the best for you. And so since I wanted to keep this one quick because I did realize it was Inauguration Day and I want you to be able to watch that and take part in that, and I'm thankful you all joined me for this little bit. Here's my final thoughts. So your estate plan is a living document. Make sure to treat it this way. You don't want to think, oh, I did this and I'm done. It's set in stone. I never need to change anything. It is a living document. It is not set in stone until you die or you're incapacitated. So we need to make sure with changes in our life, such as the births, deaths, marriages, divorce, all those things, we need to make sure we're looking at changing our estate plan to meet those needs. With the changes in laws, changes in every administration, that's when you want to make sure your estate plan is doing what's best for you during that time. So the thing is, Congress and the president, this whole thing is changing every 2 years. Make sure to keep up with changing laws and regulations regarding the estate tax. Now, I will say, if there is a huge change to the estate tax, I assume we're going to see it all over the news. So I would, and you're going to see it when you get on Facebook, all your friends will be talking about it. So maybe don't always listen to them. Go talk to the professionals in these areas and see what's best for you at this time. But I do think you'll see it if you see that there's changes in the estate tax law. It's going to be everywhere. And I also think it's important to check in with your team of professionals every 3 to 5 years to make sure you didn't miss anything. So right now, we have an estate tax limit of $22 million. Most of us aren't going to have to worry about it. If you do, you have really, this shouldn't be that big of a deal at that point because you have the 22 million or 11 million for an individual. But if we do see it go down to 3 million, 3.5 million, that's going to impact more people. So I think it's important to always look at this and see, do I need to change it? Has there been changes? It could go up again. We could get to 30 million. So at that point, probably nobody much here in Spartanburg or in the state is going to have to worry about it quite as much. But I think that's important for us to always look at and be aware of, that there is an estate tax. And right now it's not impacting most of us. It could change and impact more of us, or it could stay the same. But I think that's something you always need to be aware of. And I think we always see changes with those retirement accounts, like the Secure Act changing our minimum distributions, and it's changing our time we have to pull the money out. So I think if there's another Secure Act change, I do think that we will see changes in that. We'll see it on the news and everything, and it could be changed. So I think it's important to always be in touch with people and be updated on these so you can make sure you have the best estate plan with the best tax benefits for you and your family. So since I did want to keep it short, that's kind of all I have for today. We'll do a more in-depth one kind of on a taxable estate planning in the future, dealing with what it is at the 22 million exemption. The strategies are still pretty much the same for the most part when we go down to a lower amount or higher amount. It just depends who all is in that bracket. So later on in the year, we'll talk about maybe some tax implications with estate planning a little more. But I do thank you all for joining me today. And if you have any questions, as always, feel free to email me or give me a call. And we'll be hosting another webinar in February. So I'll definitely be sending out links to that. And this will be on my YouTube page. And I'm happy to stay on a few minutes if anybody has a question. I would be more than happy to answer. But if nobody has any questions or you want to ask them privately, feel free to email me. And thank you all for joining.